Thank you, Dale. Morning, everybody. Okay, before we talk about some recent effort on China patent law reform, I'm sure some of you may wonder who Mandarin is. So I'm going to give you a brief introduction about Mandarin. Mandarin is the largest medical device company in China, and the company was founded in 1991. So we just passed our 25th anniversary last year, and the headquarters is in Shenzhen, in China, and that's the Mandarin headquarters building and the Mandarin compound located in the high-tech industrial park in Shenzhen. And our 2016 revenue is about 1.4 billion US dollar, and the company has about 7,300 employees from over 40 countries, and we have 31 domestic subsidiaries and 41 international subsidiaries in 32 countries, and our products serve people in over 190 countries. And Mandarin provides complete solution that are integrated across all hospital departments, and we offer a full line of medical devices that cover patient monitoring and life support, in vitro diagnostics, medical imaging, and surgical equipment. For our patient monitoring and life support, we make patient monitors, we make anesthesia machines, we make ventilators, and also ECG machines. For our in vitro diagnostics business, we make blood analyzers, biochemical analyzers, and immunoanalyzers, and also we make the reagents that need to be used with our analyzers. For our medical imaging business, we make ultrasound machines, both black and white. We make digital radiology like X-ray and MRI. For our surgical business, we make the surgical bed that used in the operation, surgical bed, lighting, frame, and also accessories and consumables that need to be used during surgery. So we have 8 R&D centers worldwide. 3 of them in the U.S., 5 of them in China, and the primary research and development hub is located in our headquarters in Shenzhen. And every year, Mandarin invests about 10% of our annual sales back into R&D, and we are our total R&D investment each year exceeds the combination of the next 5 medical device companies in China. So we invest a lot in research and development, and we have a R&D force of 1,700 R&D engineers, and 65% of them have advanced degrees. Each year we release about 10 new products, and so far we have about 2,600 granted patents and pending patent applications worldwide, and 85% of those of them are Chinese patents and applications, and 15% are US and EP patents and applications. Okay, so that's about Mandarin. Before we talk about some of the recent efforts in patent law, in the patent law reform in China, can I have a show of hand who files patent application or who files IP protection in China, or who advise clients? Okay, a lot of you are good. So I'm pretty sure the information here will be of value to you. So first, I'm going to talk about the draft of Fourth Amendment to the China patent law. Then I'm going to review some of the key revisions to the guideline of patent examination. The guideline for patent examination is similar to the MPEP in the US, and also the examination guideline for EPO. And also, I'm going to talk about some draft revisions to the we call it a prioritized patent examination. Basically, for some type of technology or some type of application, you can apply a prioritized patent examination so that your application can be put in front of the queue for quicker examination. And at the end, I'm going to review a couple of recent cases that may be of interest. Okay. For the patent environment in China, I believe it is definitely moving towards the right direction. Okay, from the legislative perspective, the patent system is continually improved, and I'm going to talk about some of the recent effort in the legislation part. And in the judiciary aspect, the patent litigation and the damage award are considerably increasing now. So let me give you some statistics. So in 2016, the number of patent litigation cases that were filed in China exceeded 12,000 cases, and that's represent over 6% increase over 2015. And in the recent case, Huawei versus Samsung, the court awarded damage 80 million RMB. So it's about 11 or 12 million US dollars. So that's a lot of money, or that's a significant damage award that has been awarded by the Chinese court. And using mandarin as a example, last year we completed a IP case against one of our Chinese competitors, and the damage award also about 30 million RMB there. So that's also the highest damage award that has been awarded in the medical device litigation in China. So the damage award is definitely increasing. That's part of the effort for the Chinese government to increase IP protection in China there. And at the Beijing court in 2015, the average damage award is about 450,000 RMB. That's in 2015. But in 2016, that number jumped to 1.4 million RMB. So jumped three times, just 1 year. So you can see that at least the damage award aspect, the court is doing a lot of work, address the issue that or concern that the damage award in China is relatively low. Okay, in the patent office, in the administrative aspect, so the number of patent applications are still increasing significantly, but the rate of granting patents at the CIPL has decreased slightly. Part of the reason we believe is the patent office now put more emphasis on the quality of the granted patents, so that to reduce the number of junk patents in the system there. So let me give you some statistics. So for in 2016, the number of new applications filed is about 3.5 million cases, and that represents about a 24% increase over 2015. The number of applications for Invention is about 1.3 million. So that's represent an increase of over 21%. For the utility model, it's 1.5 million. So it's represent an increase of about 31% over 2015. The design pattern is 650,000. That also represent about, over a 14% increase over 2015. But the grant rate for 2016 for invention patents has decreased from over 64% to less than 60%. So dropped a little bit. So in the enterprise aspect of companies, we see that the company the IP awareness in the companies has definitely improved or enhanced. We see less and less direct copy by our competitors. We see more and more, we call it smart copy. So basically, they still try to copy us, but they do a lot more work. They do a lot more design around. They do a lot more improvement. Even though they copy us, but they're well prepared to challenge our IP in the patent re-examination board. So the IP awareness is definitely enhanced there. Okay. China, here is some history about the China patent law. So the patent law became effective in 1985. The first amendment is 1992. Second is 2000. Third is 2008. So the trend is about every 8 years we have a amendment to the patent law. But for this time, the fourth amendment looks like the trend is going to be broken there. We believe part of the reason is that this amendment involves the balance and the check of a lot of interest from different entities and parties. So it took longer than we expected. So the draft was released in 2015. So the draft now is before the National People Congress for approval. So we believe it should be able to come into effect in 2018. So some of the key amendments. First, I'm going to talk about some new addition about the patent eligible subject matter, and talk about some changes on the design patent. And in this new amendment, they add enhanced damage for willful infringement. Basically punitive damage for willful infringement. And at this part, I'm also going to talk about a revision of a burden, a shift of a burden of proof when the court calculate the damage award. Finally, I'm going to talk a little bit about service invention there. So patent eligible subject matter now partial design. It's patent eligible now. Before, you can only file design applications for complete design. Now partial design is available now. Method for diagnostic and treatment of disease is a barred subject matter in China, but this time they carve out the farmed animal. So for farmed animal, method for diagnostics or treatment of disease is patent eligible. So if you have client in this area, your client should consider file some patent application in this area. So design patents. So this amendment also will make some changes for the design patent. The reason is that China wants to join the Hague Treaty for Industrial Design. So they make some changes there. First, the duration for design patent protection increased from 10 years to 15 years. We believe this change may not be that significant because right now the product design changes very rapidly. So 10 years, most of the time, is adequate protection for us. And also at this time, they add, we call it domestic priority to put the domestic applicant on the same footing as international applicant or foreign applicant. Basically, they said within 6 months from the date application for design is first filed in China, then if the applicants file another, for example, an application for invention patent for the same subject matter, he has 6 months of grace period. So 6 months of domestic priority. So okay, enhanced damage for willful infringement. So if the court find the infringement is a willful infringement, and the court may, based on the infringement circumstances and the infringement scale, the scale of the infringement, whether or not it's repeated infringement, whether or not it's a mass infringement, whether or not the infringement has a bad face, things like that, and also consequence, the impact of the infringement. The court can double or triple the damage amount, basically punitive damage. So this is basically to address the concern or issue of the low damage award in China there. Okay, this one is talking about a burden, the shift of burden of proof. So let's say if the court has already found a patent infringement, so when they calculate the damage, what they can do is, okay, if the patent owner has already made his best efforts to provide evidence of damage, but in some situations it's very difficult for the patent owner to prove the actual damage or the infringing profit, because those information are actually in possession of the alleged infringer. So in that case, the court can shift the burden of proof to the alleged infringer, ask the alleged infringer to provide their account book, the infringement material, if those information are in the possession of the alleged infringer. And if the alleged infringer refuses to provide those information or provide false information, then the court can just go ahead and determine the damage based on the patent owner's claim and evidence there. So I'm going to later on I'm going to show a case that the Beijing IP Court has already do something like this. So shift the burden of proof to the alleged infringer. Okay, service invention. Of course, if the invention was made by performing the task of the company, yes, that invention should be belongs to the company. If the invention has nothing to do with its work, of course, it should be belong to the inventor. And before this amendment, this part, so if an invention made by a person using the material and the technical means of the entity to which it belongs, before this part automatically belongs to the entity. Now the first amendment changed. Basically, it says if there is a contract between the entity and the inventor that says this kind of invention belongs to the entity, then the court is going to follow the contract. However, if there's no contract, this invention is going to automatically belong to the inventor. And also in China, the law requires that the company compensate or compensate the inventor for the invention, for the service invention, at least at the grant when the patent has granted. Or another point is if the patent has been implemented commercially and derived economic benefits from the implementation, then the entity also has to compensate the inventor at least commensurate with the economic benefit derived. So if your company has a subsidiary in China, or if your client have a branch office in China, you need to make sure that you have the appropriate contract in place to prescribe the ownership of the invention, and also have an inventor compensation scheme to compensate your Chinese inventor appropriately. So next, okay, talk about the guideline for patent examination. The first version come into effect in 2014, and the revision come into effect this year, April 1st, this year. Okay, so the first revision is to a section relating to mental activity. The reason, okay, is that that section covers a business method, because in China, business method considered as rules and a method for mental activity. So for the new revision, it specifically point out that if a claim includes both technical feature and business method, the examiner cannot just reject the claim solely based on the presence of the business method. Make it clear. However, the business method itself, pure business method, are still a patent ineligible subject matter in China. I think part of the reason they make this clear is because there are right now in China there are a lot of innovation on the new business model, especially related to the internet industry. So they want to make it clear that technical feature plus business method can be okay. So the next revision, key revision is Invention related to computer program. So basically, okay, it's first it said, okay, computer readable medium plus software computer program. It's okay. You can draft a claim like that. And also, the computer program can be part of a device claim. For example, if I have a claim for a device to implement the computer program, then that computer program or software could be part of that claim. However, so pure software is still patent ineligible subject matter in China. It just inventions relating to a computer program. If you draft the claim in the correct format, you'll be able to get protection on your software. The next revision is relating to the chemistry. So before this revision, the applicant cannot submit experimental data after the application has been filed. Now they changed that. Okay, they said, okay, so long as the experimental data that after filed is to prove some technical effect that has been expressly or implicitly disclosed in the original filed application, then the examiner must consider the experimental data that submitted after the application has filed. So give a patent applicant or for applicants for the chemistry invention more opportunity to like address inventive step, things like that. Okay, go faster. Okay, this one is also very interesting. So before in the invalidity proceeding, you can only delete a claim. You can only delete a feature or combine the claims. So that's very restrictive. Now they allow you to add one or more feature from a claim. You don't have to combine the claim. You can just pick a feature from the claim and add it to your claim. And also you can change the obvious error in claim. I think I can, okay, here the key point is now you can inspect the prosecution history of published pending application. Now, before this revision, you cannot do that. Prioritized examination. Okay, quick. So before only invention patent and also on the substantive patent examination. Now they expanded to include invention, utility model, and design. Patent examination or the patent re-examination. Re-examination is after the final rejection. If you don't agree with the patent office, you can apply for re-examination, and also invalidity proceeding. Okay. Because my time is running out, I don't want to take other people's time, and let me just go very quick on those two cases. Okay, for this case, this is the first standard essential patent case that is ruled by a Chinese court. One interesting observation is they issued a permanent injunction, even though the patent is a standard essential part. And part of the reason is the defendant, Sony, was unreasonable during the negotiation between those two parties and caused the failure of the party to reach a license agreement. And also in this case, the court tripled the royalty rate against Sony. So for this case, this case I talk about. In this case, the defendant refused to provide their financial data, so the court just award the damage based on the plaintiff's claim. It's 49 million RMB. It's a significant amount of damage award. Also, in this case, the court support awarding of a legal fee by hours, and that's the first time in China. 1 million RMB. It's also a lot of money there. Okay, thank you very much for your attention.